Namaskara and welcome to BIC Talks, a podcast brought to you by Bangalore International Centre, where we present conversations that move, inform, and encourage discourse.
There's a wonderful book by a lawyer from Hyderabad, Kannabiran, where he says that the judiciary treats the state like an errant child, not really like somebody who has breached some laws. So judiciary gives the executive a long rope. The executive is not taking that, and they actually misuse that. They know that, there's no serious effect. I know bureaucrats complain about contempt cases, but look at the number of writs filed against the state and the number of cases that end in contempt. It's a very small percentage. So it's not as if the executive is shaking in fear of the judiciary. That's not the reality. The judiciary is normally cautious in intervening in economic policies of the state. They have consistently said, it's not our job. Okay, I know you have the odd judge here and there who thinks he knows everything, but generally that's been the policy and they've stuck to it. Economic policies, specialized, technical choices, the judiciary doesn't get into it.
This episode will explore how the Constitution of India frames the concept of economic freedom. We often think of the constitutional guarantee of freedom in terms of the freedom of speech and expression. This discussion moves beyond this framing to examine the oft-ignored aspect of economic freedom for individuals and organizations. Karthik Muralidharan, the Tata Chancellor's Professor of Economics at the University of California at San Diego, together with Harish Narsappa, Senior Advocate and co-founder of DAKSH, will discuss the balance between state intervention and individual economic rights, exploring issues like onerous licensing and compliance requirements for businesses, property rights, and the right to trade, occupation, profession, and business. This episode is adapted from an event that took place in the Bangalore International Centre in September of 2024.
When we were thinking of the We the People series, one of the things that we thought about was to also include a discussion on the economy. It doesn't come naturally to lawyers and students of the Constitution to talk about business and the economy. But we also fail to realize that many important cases actually focusing not just on the right to conduct business and trade and profession, but that also has transgressed into and assisted in the development of the freedom of the press, for example, because press is also a business by nature. And so there are many important cases in constitutional jurisprudence that we study which originate from business. And many important rights actually come from cases that business houses take to the Supreme Court. There is a bit of resistance sometimes. People say, why should we recognize, for example, the right to compensation to rich business houses? I was talking to a couple of lawyers about it and said, actually, the people who can take some important cases to the courts are people who have financial backing. So it is people with financial backing that are able to agitate very important constitutional rights. Seemingly, at first blush, in the area of economics or considering or concerning their own businesses, but also that can have a significant impact on other rights. In that background, we said that we have to have a discussion on the economy and the Constitution, because most people who, at least as lawyers, I'm not sure about economists, and I'd like Karthik to comment on that, but most lawyers, when we read the Constitution, we see the preamble and say, okay, we are a socialist economy, and our understanding of the economy and rights flowing from the economy then is viewed from a socialist sort of background. And then we had, the 1991, deregulation of the old socialist laws, that came late in the 60s and 70s. And then there was a big debate, at least I remember in my first few years of law school, we were debating as to whether this liberalization is even constitutionally valid, for example. I'm giving this background because I feel that's how lawyers approach it. So when we look at economic freedom under the Constitution, it's within the framework of the rules that govern right to conduct business, the rules of equality, to some extent, property, which has been a controversial area from day one, from 1951. In fact, the right to property was removed pretty much within a couple of years of the republic coming into existence from the fundamental rights and moved to some other. So we have all that in mind. That's sort of the philosophical and constitutional jurisprudence background. And then you have the constant refrain from business leaders, business houses, how we are in such an over-regulated economy that it becomes impossible to conduct business and the cost of compliance is very high. Innovation is getting stifled. I mean, you talk to a whole generation of entrepreneurs who have, moved away from India to Singapore and, the US and other parts of the world, and they talk about this over-regulation with extreme licensing requirements, extreme compliance requirements, which makes it difficult. And I remember one client once told me that, listen, I spend 40 to 50% worrying about compliance. Whereas if I was in a country that is less regulated, then I would spend 95% of my time thinking about business and innovation. And that's sort of got me thinking about, how do we characterize economic freedom within the framework of the Constitution? But then you start reading the text of the Constitution, and I was sharing some provisions with you, and Karthik sort of told me, okay, you tell me which provisions of the Constitution I should read to prepare for this topic. And then if you look at it, there's nothing called economic freedom in the text of the Constitution, right? I mean, in fact, if you start from the preamble, it's economic justice. And that's where, we started discussing. But then you have 19(1)(g), which talks about the right to carry on business, trade, profession, or any other activity. But that's not an unrestricted right. It's a right which is regulated through the provisions of 19(6), which allows the state to impose qualifications, licensing requirements, and other things. And that's been an area of contest. It was a significant area of contest until about the 1980s, 1990s. After that, we haven't seen too many cases in that. There are some, but not too many cases. So just as a background to people who may be new to this intersection between constitution and economic freedom and economic rights. So Karthik addresses many of those time-tested questions about the Indian state and capacity and our seeming failure to address certain fundamental issues. That state capacity, which he talks about in a significant manner, impacts economic freedom because the regulatory ability of the state is linked to the capacity it can. I mean, what's the point of passing all these laws if you don't have enough capacity to implement those laws in a meaningful mechanism or to actually understand the regulations that you have drafted? The executive needs to understand the regulations to actually implement them. So that's the sort of link that comes to what Karthik is in the recent work that Karthik has published. So Karthik, I think if I can start in terms of the first question, I recall your first reaction when I told you about economic freedom and the Constitution, and you sort of straight away, threw economic justice back at me. So if I can ask you to look at the relationship between economic freedom and economic justice and the ability to do economic justice of the state. And then as a civilizational goal, if economic justice is an identified goal, which it is in our preamble, to give to all citizens, economic justice, among other things, then where would you start? Because, do you start with, like, say, the US, where the citizens have a lot of rights? They can pretty much do what they want, subject to what rights they have given to the state to regulate them. Whereas where we have started from, that is, we accept economic justice as a goal, which by its nature gives the state a more central role in not just identifying economic goals, but also directing economic activity in some fashion.
So let me just take a step back and say, a few foundational things, right? So when we talk about rights or freedoms or justice, there are two very different worldviews that you can come from. Okay, so one is essentially the economic right, where we're talking about economic freedoms. It's the freedom to not be expropriated by the state. Okay? And that has a long tradition in Western constitutional law, especially in the US. And in many ways, kind of the project of the modern state itself was about putting restrictions on the sovereign. It's true, and on a slight tangent, but you'll see why. So one of the things I highlight in the book is when people look at Indian democracy, Ram Guha, who's a famous Bangalorean, famously calls it at the end of his book a 50-50 democracy, right? So there's been some successes and some failures. And Ashu Varshney says something similar. And I think I have a very simple theory of this, right? The very simple theory of this is that essentially the evolution of the modern state has gone through three major phases, right? Where for most of human history, the nation state was essentially a security state. So the only thing you did was law and order and defense, and that's where most of your budget went. So it's only in the 19th century that you get the second phase of the state, which I call the industrial state, where governments come and start building massive public infrastructure, roads, railways, canals, sewage systems. And that's the first time when you get sustained economic growth, right? And along that economic growth, you also get growing inequality. So along with that process, because the benefits of growth go to people with physical capital, financial capital, human capital. So you get that growth and inequality. And then it's only in the last 100 years that you get the third phase of the nation state, right? Which is the welfare state, where the state now says, I'm going to use progressive taxation. And this is why, I'm giving you this detour because it's obviously connected to economic justice, that I'm going to use progressive taxation as a state to then fund a series of what I consider essential welfare programs, right? So whether it's food security or unemployment or health insurance. The interesting thing is that these three phases of the state, so there are two key facts, right? So one is welfare states are expensive to build, okay? So most high-income countries built their welfare state after reaching a GDP per capita of about $18,000, $20,000, $15,000 to $20,000 in 2011 dollar adjusted terms, okay? The second important thing is the extent to which the nature of the state is correlated with the extent of democracy, okay? So when you have the security state, there's really no concept of human rights or individual rights, right? And then what's interesting about this industrial state phase is that it happens at a time of limited democracy. While the US and the UK think of themselves as great old democracies, the vote is restricted to white property owning men. Okay? And so what that means is that this is a demographic that then cares about the capital expenditure and you get the political support. Now, why am I giving you this background? Is because when you think about the notion of democracy itself has kind of evolved from the beginning as kind of constraint on the sovereign. So it's not democracy, the evolution of the state, I think, towards a more liberal state, right? So from the perspective of that property owning class, the restrictions on the sovereign with regard to expropriating private property was then one of the most important sources of freedom that was placed, okay? So I'm just giving you kind of this historical background for where these two very different conceptions of economic freedom come from, right? So there's a conception of economic freedom that says I'm free from being expropriated by the state, which is what we associate with the US Constitution. And that was considered like essential preconditions for people to be willing to make the investments, okay, that would get you growth. And then, but it's not an accident that the welfare state happens only after universal adult franchise. And so this, even in the US, is kind of only about 100 years old, and certainly like in the UK. And so in any income distribution, if you're in the left of the median, you want more redistribution. If you're on the right, you want lower taxes, which is why kind of the discourse in tax-paying elite circles in the city and everywhere is a complaint about a politics essentially being about freebies, right? So it's the same pattern that plays out in every part of the world, okay? But the point, therefore, is this third conception of then the role of the state. See, at the end of the day, the rights you can talk about, there are different philosophical conceptions, right? So one part of the freedom, economic freedom, is freedom to not be expropriated by the state. But then there's this other conception of freedom, which would say that given that people are the arbitrariness of the original position that people are born into, that you can't have a meaningful sense of economic justice or economic thing or even freedom without empowering the most marginalized to at least have a certain amount of economic purchasing power that gives them kind of a voice in the economy, right? And I think the origin story of the Indian Constitution reflects the fact that we are unique in human history as having been the first major country that had universal adult democracy on day one, right? And so that in turn means that the direction of what the Constitution is prioritizing is not economic freedoms in the sense of prevent you expropriating of the state, but economic freedoms in the sense of providing freedom to the poor, and that is therefore rephrased as justice, right? And so which is why the word freedom doesn't show up, because everybody understands that getting any sense of economic justice is not going to happen without the state kind of playing the central role. And I think in that sense, India was really fortunate that in Dr. Ambedkar, you had somebody who was not just somebody who cared about justice, but also had training in economics, and therefore kind of recognized that you couldn't legislate, the point of positive and negative rights and putting these things in the preamble and the directive principles as opposed to kind of actual rights in terms of economic rights. But the idea of economic justice in the Constitution, I think, reflects our origin story, which is a universal adult franchise democracy on day one. And given that distribution of income and kind of the economic suffering that people were going through, that it was inevitable as a result of that freedom moment that you put more priority on that. But the point I want to make that's broader than that, because I'm not the lawyer, I'm the economist, right, is that at the end of the day, both of these positions can have some first principles justification. Okay, so there's a first principles justification to say that people, whatever, there's a certain natural order that exists that people should be free from expropriation. You could make a strong philosophical argument for that. And you could also make a philosophical argument for saying that there is a certain moral arbitrariness about the original position, and therefore there is a case for public intervention to kind of remedy that to the extent possible, right? And so this takes us back to like Rawls and Nozick type debates, right? So as an economist, to me at the end, I think there are viable ethical positions supporting both these views. And then it really becomes an empirical question as to what is the set of rules that then allow you to kind of deliver against the aspirations of economic justice. And that then gets to, I think, our own economic journey, and which is why you can't kind of divorce the legal journey or the constitutional journey from kind of the economic journey of the country, which is the recognition that the socialist turn we took, for the most part, didn't work in terms of generating the surplus that was needed to then provide economic justice, I think has then taken down the path of saying that we need the economic growth. Now, what I don't know is the extent to which this has happened in a jugadu way, where the laws have still not kind of clarified the roles and rights of kind of just commercial enterprises, businesses, and allowing more freedom. But to the extent that the political ethos of the country still very much focuses on justice and kind of, redistribution, it's useful to observe things like NREGA, which are an outstanding program, could only happen after 15 years of economic liberalization and growth, when you then had the fiscal space, to kind of do that kind of welfare. So it's a long way of saying that one could argue from first principles different conceptions of freedoms and different conceptions of justice. But in the end, it's an empirical question as to what set of policies and laws are going to get you to the place where you're able to best deliver against those aspirations.
In a way, you're sort of characterizing economic freedom as a freedom that exists in certain conditions.
Sorry, I should clarify one thing. I think I've focused more at the individual level and not at the enterprise level. Okay, yes. So I've been focusing on freedoms at the level of, the individual citizen. If you're born into absolute poverty, what does it mean to have the freedom? So when Amartya Sen says development as freedom, right? You could argue that there's a certain element of freedom that requires the state to invest in you. So which is kind of, as a development economist, that's kind of the lens I'm coming from. I think there's another lens here, which is about freedom of economic activity of entities, of organizations, of small businesses, which I haven't covered here, but I'm happy to kind of come back to that as well.
What I was struck by was how you characterize economic freedom. Because when lawyers talk about economic freedom, or most lay people talk about economic freedom, okay, the ability to do any business activity or sort of income earning activity that you want without any restriction. But you have placed it not just in a moral and justice space, but in the context of a civilizational space, as to that it's not just, going and opening a shop. There's a much larger goal to it. And that's what I think it's interesting. Even for informed lawyers, this is important to know, because what you're saying is you can't even characterize economic freedom as an absolute freedom to just do some economic activity. And that flows from something else, I think, is what I understood from what you said, I think, which is an important point. But following from what you've characterized in terms of economic freedom and historical juxtaposition and how India has been unique in terms of starting universal adult franchise and then adopting economic justice, because without that, then universal adult franchise, I suppose, was meaningless in some way, because you're promising economic social justice and then not just economic social justice, but you promise many other things, but then that was accompanied by universal adult franchise. So in that context, if we move on to the next stage and see how the state has done, and I know this is now your favorite topic in which you spent a lot of time in your book, what in your view is the ideal role of the state? Ideal sort of role of the state, both in terms of capacity plus in terms of what it needs to do to achieve this economic justice and economic freedom.
Yeah, and it's interesting. I was telling Harish, right? See, I'm not a lawyer at all, right? And so the way I think about all of this is that I think about policy choices being negotiated in a political space, and then laws as being the mechanisms for then formalizing what is kind of, the political agreement as to what we should be doing. Now, there's a different fact that there's often a huge lag between or gap between the intentions of the law and the capacity to implement. But since you've kind of given me a very, very broad canvas again in terms of the role of the state for economic justice, I think there is something to be said for each of those conceptions, right? Where the first role of the state is really freedom from expropriation, right? Safety, coming back to those three phases of the state, right? That the security state is still essential in terms of getting just basic law and order, absent which you don't have meaningful economic freedoms, right? So you are then in the law of the jungle, okay? So that, I think, is still the fundamental role of the state, is kind of the security of kind of person and property to the extent possible. And so that's essential. I think the second part in terms of how does a state contribute to economic freedoms, and if you come back and think about the second phase of the state, is that the economics of government intervention in something is very simple, right? When should the government intervene? The government should intervene when there's a market failure or when there's a coordination failure, whereby the government is able to, with the same amount of tax dollars, provide a better outcome than individual citizens with that same money in their own pockets, okay? So if you think about the original logic of a government school, right? The logic of that school is earlier education used to be each person just paid for a tutor, okay? But what you're doing with the school is solving a coordination problem, right? What you're doing with government spending on infrastructure is solving a coordination problem that will not happen if individuals are doing this on their own. Coming therefore to that second phase of the state, what I'm calling the industrial state, where public action kind of substantially promotes economic freedoms, is when you provide the public goods that would be underprovided by individual agents. Okay, so then, but again, what this is eventually doing is augmenting the freedoms and capacities of individuals, but by providing the public goods. Okay, so that's kind of the second phase. And then the subtle point about the third phase, okay, when you come to welfare, and this is, I think, intellectually one of the key points I want to highlight in the book, is that often economists consider that it's almost axiomatic that there's a trade-off between equity and efficiency. Okay? That if I want to do welfare, there is going to be an efficiency cost, because in public finance economics, it is almost axiomatic, because to do welfare, I need to raise taxes, okay, and then I have to give it away. So in public finance economics, it's almost axiomatic that this comes at an efficiency cost, because if I'm raising taxes, I'm reducing the incentives to work. And if I'm redistributing, I'm potentially hurting incentives to work again. But I think what makes development economics, I think, fundamentally different from public finance economics as an intellectual enterprise is that a core idea of the field of development economics is the idea of a poverty trap, which is when people are extremely poor or when countries are at very, very low levels of capacity, that you can often have no trade-off between equity and efficiency, where you can have interventions that help the poor, that also make them more productive, which means that that is the free lunch, okay? So I'm coming back to then what is the role of the state? The reason I'm focusing there is there are elements of what the state could do, okay, that promotes economic freedoms of the poor by redistributing more. But that comes at the cost of kind of infringing on economic freedoms of the rich because of that taxation, okay? So eventually that is a political decision, okay, on which as an economist, I don't have an ex-ante view one way or the other, and reasonable people can disagree. But what I want to point to is the fact that if you look at where our public money goes, you can think about our public finances on a two-dimensional kind of 2x2 of equity and efficiency, where the efficiency axis would say that any private CFO would not be able to deploy 10 crores without doing a complex discounted cash flow to say, like, is this an ROI positive investment? But in government, we routinely spend hundreds of thousands of crores without anything close to that kind of scrutiny on whether this is getting that ROI. So the first principle for quality of public expenditure I'm talking about is kind of that the public spending should have a high ROI, or at least above the cost of borrowing, right? So that's kind of in that second vein, because if you're doing that, you're enhancing kind of the capacities and overall productive capacities. But when it comes to equity, you can use the same discipline there, because obviously the government is not a profit maximizing enterprise, and the government is also trying to maximize certain social goals, okay? So equity is absolutely important. But if you look at the details of how we spend our money on welfare, you'll see that there is enormous variation in the quality of that welfare expenditure. There are some kinds of welfare spending, and you'll see why, so the answer to everything as an economist is it depends, okay? So it's never going to be an absolute, okay, of saying that this should be privileged or this should be privileged, because it always depends on the details, okay? The details matter a lot. If you just look at the gamut of the policies we do for rural welfare, on one hand, you have something like the NREGA, which is an outstanding program that promotes both equity and efficiency. It promotes equity because it's a welfare program that targets the most marginalized, who are typically landless laborers. And it promotes efficiency because you often have kind of monopsony market power of landlords that are counteracted with NREGA. And we now have evidence that this contributes to kind of a local demand multiplier, and that contributes to both equity and efficiency. So that's the kind of action a government would take that would promote economic justice and also support kind of overall growth. On the other hand, where does most of our money go? Most of our money goes to things like free electricity for farmers, which might be one of the worst policies like we have in the country, right? Because if you think about kind of a taxonomy of quality of expenditure in terms of targeting, delivery, and distortions. So if you look at targeting, basically about 5% of the richest landowning farmers capture about 50% of the total subsidies because the subsidy is proportional to land holding. Okay, so we say farmer welfare, but it's one of the most unequal kind of welfare spending we have. It is a disaster for delivery because by not metering ag power, your discoms essentially have a lot of their transmission and distribution losses hidden under that, and which in turn means that the discom fiscal viability is one of the biggest crises we have. And the last is the overall distortions to the economy. The distortion to the groundwater table. Our water crisis is fundamentally an agriculture crisis, right? Because 80 to 90% of our water is used in agriculture. The mindless application of free electricity for farmers is in turn the cause of a whole bunch of downstream problems. The reason I'm giving you this is that, again, as an economist, to me, one of the most important, the laws set a certain set of boundary conditions and goals, but in the end, it's all about the details, right, the program. So coming back to then what you said about what should a government do independent of the law with regard to promoting economic justice and economic freedoms, there are actions that are about securing property, right? There are actions about providing public goods that would not otherwise be provided. And then there are actions that are well-designed welfare programs that can kind of promote individual freedoms by kind of helping people jump over a poverty trap, okay? That they would otherwise not be able to jump over. One thing I can talk about is in the welfare chapter, right? I talk about the value of something, not quite a UBI, but an inclusive growth dividend, which is pegged at a lower amount, but that's a modest income transfer to everybody. And that's because coming back to economic freedoms, this is a very, very deep point, right? Because so much of our public discourse is essentially polarized between saying, oh, we need to do more capex for kind of development and we need to do more welfare for immediate kind of alleviation of suffering. Okay, that's kind of where the bulk of our public discourse is. Okay. But the free lunch that we have as a country is that if you look at the details of the expenditure, there are many, many spending ideas that would promote both equity and efficiency that we are not doing because most of our money is going into areas that are bad for equity and efficiency. So if I have the 2x2 quadrant, reasonable people can disagree on the second and fourth, but we should be able to build a broader consensus to say, identify areas that are here and let's move over here. There's a meta point here, right? Which is every time you ask a conceptual question, I come back with examples. And that's partly because it's all about the details. The meta point I want to make is kind of build a much stronger community of the empirical analysis of laws. Because in the end, that's kind of what matters. And we'll spend more time on that at the end.
So in a way, what you just said is that economic freedom of the individual at the lower end of the income earning capacity is the state can even give them some what you call direct transfers or increase their income earning capacity by putting in more money through capacity building for them, through education, through, you said, if it's a household of 4, then it's only about 600 rupees or so. In your book that you talk about that. So you're expanding their economic freedom and income earning ability, which is a different way of looking from, oh, why are you wasting your money on tax money, my money, somebody else's money, and you're distributing it to the poor just like that. But you are saying that actually increases economic freedom at the so-called bottom of the pyramid. And that's a very powerful takeaway in my view. But if I then look at it, is there a difference between how economic freedoms of poorer people should be conceptualized as against people who are above a certain economic level? What capacity should the state develop to even think of increasing these economic freedoms? Because at the end of the day, when we're talking about the constitution and economic freedom, so what other capacities it should develop? And I think you talk about state capacity, the need to decentralize developmental goals and economic goals at state level rather than centralizing it. That's one of the biggest takeaways from your book. So what kind of, does a state also then need to have some sort of economic ability and not just political ability? I mean, that's a question I have for you. So if you can take both those questions and then...
And the reason I kind of spend so much time on this equity efficiency framework is that it's a very slippery slope to go down the line of saying redistributing more to the poor should be done because it increases economic freedom. Because at some point that tax money is coming from somebody else and then you're infringing on the second and the third. So then you're in conflict, which is why I want to focus our public discourse There's this old quote by Mario Cuomo, right? That you campaign in poetry and govern in prose. Okay. So, it's very easy for kind of people who care about rights, care about justice, or, either way to take extreme positions and saying, oh, all welfare is making people lazy, or all kind of, resistance to welfare is essentially the big fat cats, trying to prevent the poor from having a chance. So I think the reason I'm spending so much time on identifying these win-wins is because what is very interesting about the NREGA example is that if you look at then the impact over the entire income distribution, it actually ends up benefiting everybody. And that's because it's not just helping the poor, but the increase in the aggregate demand that's coming from the money in the hands of the poor, what the research shows, is improves the number of kind of non-agricultural enterprises, small and medium enterprises, employment. So it's got this cascading effect up the chain that everybody benefits, that you don't see. Now, this is me making a plug for empirical research because this is a hard thing to otherwise assess. But that's why I think what is the history of the political tensions in every major democracy has been that precisely because elites are afraid, in any income distribution is right skewed. And therefore, the median is kind of below the mean. So which means in a universal voting system, there will always be more support for redistribution, which is kind of why, at least in the US and others, elites have used constitutions and other ways to kind of put a constraint on the ability to kind of expropriate the rich. So there's two kinds of expropriation, right? There's expropriating of the rich by the sovereign, and there's expropriating by a democratic state where essentially the median voter just says, hey, give me your money. So, and this is a very, very fine balance, which is why what I'm pointing to is as where we are in India, there are these win-win kind of ideas that allow you to get both of them. Now, the problem is that doesn't make for an easy enshrining in law one way or the other. But in a way, the good news is I think the framers of the Constitution recognize this, which is why the idea of economic justice is there, but the idea of a rights-based approach to positive rights, right? Whether it's food or information, was not there in the Constitution. That's kind of a more modern conception of how do you bring that into the government. So I think the two other broad things I will say, since you talked about capacity, see, there is this fundamental tension, right, between universal franchise, right? And as Ambedkar famously pointed out, in the only place where we operate on a one person, one vote principle is at the ballot box. Everything else, the market, functions on a 1 rupee, 1 vote principle. So the purchasing power you have in the market is a function of your purchasing power. So then when you come about and saying, how do you resolve this fundamental tension? So I think and which is why I kind of see that the way building an effective state, okay, so let's take a broader philosophical, ethical worldview, okay, and I think it's useful to again take that big picture view. So the big picture view here is when people see inequality in the world, okay, you can think about this like an uneven playing field, okay, you're playing a game of football. Now, you can look at this game and have two reactions. One is to say, the game is so unfair, I'm going to declare the game a draw, which is what communism or socialism tries to do. But when you make the game a draw, there's no incentive to play. So there's no game. Everybody says the game is a draw. There's no spectators. There's no game. There's no economy. Now, on the other hand, if you keep all the way this way, then that's also not a very fun game. It's not even a productive game because the person down here doesn't even bother. So what's going to be both equitable and efficient is to take that initial playing field and level that as much as possible and then saying, now go play. And so the way I kind of materialize that in practice is to say, when you think about education, when you think about health, when you think about kind of basic safety, that those are these essential public goods or kind of publicly provided merit goods that if a state is able to focus on, then what you do is you get to a place where you say, I'm not going to declare that the game is a draw with our misguided socialist policies, but I'm going to level this playing field by allowing the marginalized a shot at this game, by investing in those capabilities, which is very much in an Amartya Senian kind of framing of what is development, right? So as a state, you want to invest in those capabilities that allows everybody, a shot at that game. But then you kind of preserve a set of rules that then doesn't kind of arbitrarily expropriate from those who are wealth creators, because you then want to say, hey, if I'm going to penalize success so much, right, then again, you don't get the game. Okay, so then that does require us to go back and question some of the inbuilt assumptions in a lot of our laws, and the way the government approaches the private sector is a default of suspicion, which means that going back to regulatory burden, going back to compliance burden, since I didn't fully answer those questions, it is true that most of our governing frameworks start with an approach of prove that you're not a thief, okay, rather than saying I trust you and then I will come after you if I have reason to. But the underlying theme across all of this then is state capacity, right? Which is you have a bunch of, so how are you going to be able to deliver that education, deliver that health, deliver those things that allow people to participate? You need to build an effective state that can do that. How are you able to kind of not just have laws, but be able to implement them in a way that's less arbitrary? So the state capacity agendas, this is why I consider this a completely non-partisan agenda that both the left and the right should be able to get behind, because for the left, it's the effective state and this is why I call building a more effective state the great unfinished task of Indian democracy itself. Okay? And that's because the 50-50 that Ram Guha talks about is that the success of Indian democracy is that you've given the most marginalized a chance to make a claim on the state before their equivalents in high-income countries had that, right? Because you've given them the vote early. But the failure is that you've kind of expanded the capacity to make a claim on the state before the state has the capacity to meet those claims. And coming back to, therefore, this tension between one person, one vote in democracy and 1 rupee, 1 vote in the market. The only entity over which the poor have an equal claim is the state, right? So by kind of investing in the capacity of the state, you are investing in the promise of Indian democracy itself, right? But then that's for the left. But why should the right care so much about this? Because effectively, most of what I'm talking about in state capacity is not a mechanical increase in government budgets, right? It's because state capacity is about building effective organizations. And there is so much to be done there to improve the effectiveness of the state, improve the effectiveness of justice, law, which will also basically be the biggest fillip to economic growth. And that human development and rule of law agenda together kind of supports both inclusion and growth. So I think, that's why, because the core goal of the book is not just to put out a bunch of reform ideas, but given how polarized public discourse gets, is to kind of identify an agenda that we can build a broad coalition around. Like, it means saying this is really the rate limiting step for any kind of particular group. And then the hope is that promotes freedoms of both kinds, that it promotes freedoms of the kind that empower the marginalized to just have the freedom to have more voice and agency. So I'll give you a simple example. The connection between a well-designed welfare program and economic growth, okay? So people often think that welfare is kind of antithetical to growth, right? And that's absolutely not true, because if you look at where does growth happen? How does economic growth happen? Economic growth happens from the aggregation of individual decisions to undertake an investment that's going to give you higher returns. But any investment is risky, okay? So at the level of an individual farmer, if you want the farmer to grow a new crop, that new crop will have higher returns. But what the research shows is in the first 2 cycles, he will lose money. So there is kind of research on migration, right? I mean that migration increases income on average. But people don't migrate because they can't even pay their search cost. Modest amounts of well-designed welfare programs can then allow you to jump over a hurdle of getting to the next higher level of investment. So that's then the interplay between kind of well-designed welfare that promotes economic freedoms, which then also contributes to expanding the size of the pie.
I just wanted to pick on this expropriation right that you mentioned. And we did have a fundamental right to property when the Constitution first came into force. But then the initial few legislations that the states and the central government initiated were all set aside by the Supreme Court and the High Courts. And these were all the land reform legislations. That was one of the big promises of the freedom movement, that there will be land reforms, because, during the British and before that, we had the entire zamindari system and all of that. And because the courts set it aside and you had somebody like Nehru actually saying that, listen, where are these judges getting all these ideas from? They don't even know the reality of what we are trying to do. So then they removed the right to property from Part 3, which is fundamental rights guarantees. The right to property still exists, but as a constitutional right in Article 300A, which says that you have a right to property. But the law has also been well settled that you can't take a private citizen's property. The state can't take a private citizen's property without fair compensation. It's a different issue that most compensation schemes of large projects like dams, etc., have not been successful. Now when they acquire property for, say, highways and things like that, there's reasonably a better success now than, say, 30, 40 years ago. But even if you, sort of go around Bangalore, there are some colonies which say, for example, I see one such colony almost every day, which says the residents of the settlement scheme of the Tungabhadra Dam scheme. The Tungabhadra Dam is somewhere far away from Bangalore, but there's a small colony, in Vasant Nagar, if people may notice it, where people who got, who had to leave those areas because their lands got acquired are coming and sitting here. So that, in a way, we have guaranteed that expropriation cannot take place. But again, expropriation was the subject of many constitutional cases. One was the entire set of cases around the land reform laws. Then the privy purses, when the guarantees given to the Maharajas was taken away. Then all the bank nationalization cases. So there are many cases which talked about expropriation, compensation, and other things.
I think, the two broad sets of questions, right? I think one, since you've kind of been at the ringside of regulators, right, and economic activity, right, and the cases, and this is not something I've not paid much attention to, right? So two questions, and you can take them in whatever order. I think the first is specific, and the second is a much broader question. The first is that in the regulatory sphere, right, over the past 15, 20 years, if you can walk us through examples of how because the technologies change so fast, the possibilities change so fast beyond what is anticipated by kind of laws and regulations, right? So your sense of areas where the Indian state has done well, where the regulatory kind of, architecture has been reasonably moving alongside the possibilities of both technology and businesses. And, conversely, areas where the regulatory landscape, the inconsistent application, the uncertainty of how something may be resolved has acted as kind of a deterrent, right, to investment and activity. So, both sides, right, what's worked and what's not. And then the second much broader question is kind of from the perspective of a lawyer, practicing lawyer, just your reflections on the extent to which economic logic, empirical analysis is kind of present in legal training, legal reasoning, legal discourse, crafting of laws. And my sense is it's not much, okay? But if we wanted to change that, how would we go about doing that?
I think you're given the answer to the second question anyway. So I'll take the second question first because it's an easier question. So there's not much analysis, for example, of when you pass a legislation as to what that legislation can lead to in terms of what kind of disputes will it lead to, what capacity we need to build in either in terms of judiciary, in terms of executive, in terms of any other implementing regulator. There's not much thought. It's all sort of, hit or miss. And you'll say, okay, we'll start and then we'll see. We'll learn along the way. The easiest example is the Companies Act, right? And we had a new Companies Act in 2013. And when I was in law school in 1991, and I remember when our companies class first started, and our professor told me that this was in 1993, I think. The professor told us, I feel sorry for your batch because I don't know whether in the middle of this course, I will have to start teaching the new Companies Act. That finally came into force only in 2013, after many efforts. But even that, an important legislation, the Companies Act, there was chaos, even though they had a lot to plan. So they had chaos in the sense that they didn't figure out how many tribunals they needed. NCLT and NCLAT is still, a problem even today. Then for many, many months and almost a couple of years, we didn't know which provisions applied and which didn't, because they had included a new provision which said the Ministry of Company Affairs will notify as to when different provisions will come into force, which is okay, but, there can't be reverse engineering in terms of legislation. So there was a lot of chaos. And it was an example of what you referred to earlier, that you can't treat the entire set of people who are running companies suspiciously and say, going to assume that all of you are messing around the Companies Act, and therefore, first show me that you are good and then I'll treat you carefully or better. So that's an example. Another example of chaos is RERA, the Real Estate Regulatory Act, which is actually supposed to meant to protect consumers. But it's a chaos. Nobody knows how to enforce it in terms of builders who cheat, who don't deliver on time, still continue with new projects. And they impose penalties, they don't know how to enforce it. So in terms of thinking, in terms of building capacity and then passing legislation, I'm not even talking about economic analysis or econometrics analysis or anything like that. I'm just talking about building basic infrastructure that is required for the enforcement of that legislation. That itself is a challenge. Perhaps the biggest success, I'm now merging the two together, the biggest success is probably what has happened in the Competition Commission. And it's a relative example, but that's probably the one where they took their time. The act came into force, but they took their time in terms of before they brought everything into play. They built reasonable capacity in terms of the Competition Commission of India. But that's probably because it's a very, as a body, as a regulatory body, it's a much smaller body than say, the Ministry of Company Affairs implementing the Companies Act or the RERA. So that's an easy example. But in terms of analysis, whether as lawyers, law students, we tend to bring it on judges, right? We tend to narrow it down into rights and obligations, right? Because that's the universe in which we operate. And if you notice, even I was trying to push you to answering between different rights of different levels of people through economic freedom, but it doesn't work. But I was trying to see whether we can phrase it in that language. And that's the challenge that we have, to convert these complex economic ideas and topics, even of the welfare state, into entitlements. And the two areas where they've tried to do it is in terms of RTE and the Manrega. There's a challenge. Like, the number of writs filed in high courts for release of funds, salaries for Manrega, too much, and for a small amount of money, right? So lawyers don't think of it that way. We think of it in terms of rights and obligations, and that needs to be crystallized in the legislation. And because it's sort of dumbing down complex economic topics into sort of rights and obligations, it's not easy. And the right to education is a classic example of that. How do you enforce that? And you also write it in your book about the right to education. But you also rightly pointed out that the court has led some sort of crystallization of rights, of economic rights, and, for example, the right to livelihood, which has been read into Article 21. And it came without, economic thinking. It came from the rights perspective and said, listen, you can't take away the right to livelihood of a street hawker, for example. That's how it actually arose in Olga Tellis and other cases. But then how does then the executive, who has to deal with those rights, how do they react? Rights of street vendors is a contested space even today in every urban area, right? And then you suddenly have some demolitions happening. Then how do you reconcile that with right to livelihood? How do you reconcile that with the right to walk peacefully on footpaths? So it's a contestation of rights. And if there is a right, there has to be an obligation. And then we look to the state. And again, you mentioned we have given ourselves the right to claim from the state, but the state is probably not ready to answer these questions that is being asked of it from rights guaranteed either by the Constitution or by jurisprudence.
So one practical question that just came up from there. See, if you look at our court backlogs, right, the biggest litigant is the government itself. Okay, so among the largest sources. So there's a broader question about what is the source of this? Is it badly written laws? Is it kind of government just trying to bully its way on a bunch of things? That's a very broad question. I think I had a more specific question, right, which is going back to just what you were saying about the right to walk on the footpath conflicting with the right to livelihoods. Okay. Now, if as an executive, I want to take an action that somehow tries to balance this, is there a provision? Is there a way to almost get like an advanced judgment from a court and saying, this is how I'm thinking about it? So can you offer a view on this so that we then don't get another 20 litigations downstream on this? Or is that impossible? Because part of, I think, the paralysis often, which I see in so many aspects of government, just one specific example. This is different. But the paralysis connection comes from, for example, very few people know this. When we look at the challenges of state capacity in the executive side, the amount of cases where positions in government are not filled because they are under litigation. In states I've worked in, 40, 50, 60% of block level administrative positions are vacant. Okay, and that's because, say, in the case of teachers, they'll get hired from different cadres, different systems, and then the fight is about the seniority list. And then everybody who doesn't get the outcome the way they want will go to court, and the court will accept everything and it'll be stuck there for 5 years. The entire administrative machinery is paralyzed, because the courts are still taking their time to adjudicate on seniority lists. So, in fact, book by T.V. Somanathan, who's now the cabinet secretary, the book on state capability, they have this very powerful evocative quote where it says, personal litigation within the government is like a tapeworm that eats up the capacity of the state from the inside that nobody is actually observing from outside. I think the larger point I wanted to make is, in a world where judicial intervention is such a big source of administrative paralysis, is the judiciary even cognizant of that? Do they see this as so I think Aparna Chandra uses this framing, right? That the access to courts is not the same as access to justice. And so they give everybody access to the court and then it's there stuck there for 20 years or 15 years. There are two elements of this question. One, which came, is the judiciary cognizant of those costs and tries to internalize that in its behavior? And from an executive side, if we want to increase people's confidence that certain things can be done and the courts are then not going to retrospectively come and shut it down? Like, what are the mechanisms that exist for almost like a judicial pre-clearance, so to speak? Is that what the law ministry is supposed to do inside and kind of advise them on that?
See, this pre-clearance I don't think will work, because that then is a theoretical question. And the judiciary doesn't answer theoretical questions. So the judiciary answers factual questions. Somebody should be claiming a violation of a right and then asking what is the remedy. So pre-clearance is being tried, to my knowledge, only with the tax department.
If there are two rights that different benches have read out that are in conflict with each other,
yes,
then where does the executive go?
Yes. So there, the government very often asks for a larger bench to decide that question. And in the Supreme Court, the central government can make a reference to the Supreme Court and ask for the Supreme Court to rule on a question of law. Now, that reference is the only opportunity where the Supreme Court or judiciary exercises its judicial wisdom on a question that doesn't affect somebody's rights directly. So otherwise, the judiciary only deals with rights and obligations of affected people. The PILs are an exception, because somebody else, it's a representative litigation by people who are affected. So I think even from a theoretical perspective, it's very difficult to ask for the court to give a pre-clearance. They can only give it on the basis of the facts they deal with. I mean, you talked about economists saying, maybe or depends. I mean, lawyers are, sort of masters of that, right? I mean, I think you guys have a lot to learn from us. I think you haven't, I don't think you have ever seen a legal opinion by any law firm, I think, or any lawyer. I mean, there are sometimes the opinion is 3 paragraphs and the qualifications are 10 pages, right? So I think we need to factor that. So you can only apply the law as it stands on that day and to a particular fact situation. I think that's the basis of the judiciary's work. So the only ability is through a reference, which is possible, and that can be done. But that doesn't necessarily bind the judiciary later when there's actually a violation. So that's the problem. In terms of, is the judiciary aware that it is affecting state capacity? Yes. I mean, it is aware that it's affecting state capacity. But see, I think there are 2 points that I want to make. And this goes against the common notion. I don't think the judiciary is very tough with the state in the first place. The judiciary treats, there's a wonderful book by a lawyer from Hyderabad, Kannabiran, where he says that the judiciary treats the state like an errant child, not really like somebody who has breached some laws. So the judiciary gives the executive a long rope. The executive is not taking that, and they actually misuse that. They know that, there's no serious effect. I know bureaucrats complain about contempt cases, but look at the number of writs filed against the state and the number of cases that end in contempt. It's a very small percentage. So it's not as if the executive is shaking in fear of the judiciary. I mean, that's not the reality. The judiciary is normally cautious in intervening in economic policies of the state. They have consistently said, it's not our job. Okay, I mean, I know you have the odd judge here and there who thinks he knows everything, but generally that's been the policy, and they've stuck to it. Economic policies, specialized, technical choices, the judiciary doesn't get into it. They're only concerned about the framework within which those policies are made. I mean, whether you have followed natural justice, whether you're given opportunity to be heard, etc., right? But in terms of tying up state capacity, because the judiciary is not able to dispose of employees of the state versus the state and potential employees of the state versus the state, that is a serious issue. And that I don't think, in a way, it's a state against the state, right? Because employees of the state are the state. It's not political leadership. So it's the state fighting against the state, in a way. And that, they know each other's, dark secrets very, very well. So the challenges, and it's mostly about money, sometimes promotion, etc. And they last for too long. I think so that needs to be addressed. I think you and I were talking about having an ombudsman
I think, there are administrative tribunals, but the problem is that because the courts accept the appeals against that judgment, so then, they just keep tying it up. So anyway.
You have been listening to BIC Talks by Bangalore International Centre. If you like what you heard, Do follow us on social media. Keep up with our programming by signing up for our mailer on the website or leave us a review or rating on Apple Podcasts or iTunes. The crew that makes these podcasts possible is Gaurav Krishna and Ishan Gupta on sound supervision and production, with support from S. Sarunaraj and Raghu Tenkaila. Artwork is designed by Chandni Venkataraman of Crisscross Design Studio. Don't forget to subscribe to our channel on your favorite podcast platform. It can also be accessed on our website, bangaloreinternationalcentre.org. This is Lekha Naidu signing off on behalf of everyone at BIC.